You mentioned you are retired from Aboriginal law, so I'm just really curious what your work looks like today.
Well, I just retired from my partnership, and I retired from the day-to-day.
Okay.
And I do still do work in the courts. I was honored to be part of the Chilcotin appeal, and we've just fought a very beautiful case for the Douglas Treaty First Nations, where the courts have determined that the treaty is not a treaty of surrender, which is going to be appealed, and we're opening up arguments on that, which is all good. So it's not that I'm right out of the courts, because I'm really looking, like in the courts, to elbow jurisdictional space away from the province's assertion of jurisdiction exclusively over the territory to create jurisdictional space for Indigenous laws and legal orders to take root. And so that is still an important piece of the work that I like to do. But in terms of the beauty of the encounter, like I really feel like we have the most incredible Indigenous legal scholars at play and at work in British Columbia. To say a few, Ardith Wacom, John Burroughs, Val Napoleon, Dr. Ron Ignace. These are Jeanette Armstrong. These are Indigenous scholars who are really helping to show how to bring Indigenous laws and legal orders into play in areas of family law, in areas of criminal law, in areas of any kind of conflict, even jurisdictional overlaps, territorial overlaps, that there's a whole body. We've got to, just like in the courts, when I first started, my job was to make Aboriginal law visible. Grand Chief George Manuel, when I said, like, what is it you want? He said, I want Aboriginal title recognized. I thought that was a pretty interesting way of putting it. We now need to get Indigenous laws and legal orders recognized, and recognized among Indigenous people as being capable of solving the problems. I mean, we are a disputatious race. There's going to be disputes about everything. That's just the nature of our beast. But inside the Indigenous legal orders, there are different ways and beautiful stories and a body of law and techniques and so on that can handle disputes that come up better than going over to the non-Indigenous legal orders for solutions, especially all the time. And so I'm interested in that work and that discussion, and however I can be of assistance. I'm just a baby. I feel like I'm such a young person in that area. Having practiced Aboriginal law all my life, I feel like I'm starting again. But that's really what my day-to-day more or less looks like.
You were talking earlier about how governments are failing to properly negotiate with First Nations communities who are currently in the treaty negotiations. I have a question about conversations I've had with people about what that would look like on a legal scale if the government was challenged for the failure to negotiate. Because I mean, from what I hear, that's exactly what they're doing. They're failing to negotiate properly.
Right. That's a challenge which has had a bit of play in court. It's the good faith doctrine, failing to negotiate in good faith. That doctrine got birthed in the labor movement, and there's a lot of law from that field that is applicable to this. There's been some decisions around it. No one's gone head on and challenged the BCTC process as being a failure to negotiate in good faith. It'd be a fascinating case. I really enjoy it. I think Liz would too. We don't know what the courts would do. But one of the principles of good faith negotiation is that you don't come in with a fixed legal position, that you come in with a flexible position, and that you don't come in and say, if you say X, I'm walking. That's what, now can we talk? Like, that's pretty much what they do say, and that is not good faith principles. So it would be quite, and especially now since we've had so many international bodies say that the policy underlying their negotiating mandates is actually a violation of international legal principles. It's not, I feel like there's a really good case there, and it may get played out perhaps. You see, a lot of the problems about those that are in the process litigating this is that the government also has a policy where they don't litigate and negotiate at the same time. If you're going to be litigating, you're litigating and negotiating fine. So a lot of the First Nations that are in the process and negotiating have a lot of stake in the negotiations continuing. There's people that are employed and they've got, you know, a staff up and running, and they've got a position that they're advancing, and they don't want the negotiations to end. Some might, some do, but basically the risk of going to court, which is also expensive and rule-bound and time-consuming, and you can see that we've gone to court for 40 years. We haven't, you know, really shifted the status quo. Like, you might get a decision in your favor, but it doesn't mean to say that you're going to win. You have to work political and legal together, and there may be, you know, that politically they haven't been able to bring home. So I think we're at the tipping point on that question. I think in the next few years we'll see if First Nations take that to court, and I think that they stand a really interesting chance of succeeding. Thank you. Are you going to be a lawyer?
Yeah, that's actually where we're trying to go.
So for you. Good. I'm really glad to hear that, because we do. The younger lawyers are going to, like, as we step off the stage, you guys are going to step on, and you'll have totally different fights. Like, none of you are going to fight the extinguishment war. We've done that, but you're going to fight other wars, and it may be the good faith negotiation war will be one of your first battles. So, hands up.
Thank you.
But what are our chances of winning future cases? If our Indigenous rights cases are being tried in front of judges who are of that settler mindset?
Good, that's a great question. Okay, so Laura's right. Like, so the judge that decided the Chilcotin case at the Court of Appeal was a senior lawyer with the Attorney General's office against us in Delgamuukw. So you see the legal position that was being advanced in Delgamuukw appearing as a judgment in a decision that was singularly affected. You know, this is another reason why Indigenous laws and legal orders need to be stood up, because when you choose to go to court, about 3% of the cases that are filed in court registries actually go to court, actually go to trial, because too long, too expensive, there's problems with the and so actually going to court is an alternative dispute resolution process, because 90% more of the cases settle some other way. And it's an interesting thing to realize. So if there's been times in history where the King's Court has become obsolete, like it turns out that they're not, you know, providing solutions which people use. And that was the whole birth of the Court of Equity, where in the mid-century of a very long time ago, the King's Court was just considered to be, you know, too much in favor of the power elite, and the people just started their own courts. They called them the Court of Equity, and people would come and they would, you know, bring cattle, and they'd be deposited in front of the little room that the court happened to be in, because if somebody won, there'd need to be a remedy, and there it was waiting out front for them, and the people developed these beautiful little equitable sayings so that they knew that justice was done, like where there's a right, there's a remedy. They kind of, you know, justice has to be done and not justice has to be seen to be done and not just done. Like, all these little equitable poems came out of the equitable court, so that people knew that that's what was going to get. It was just a court of their peers that would apply this kind of law. And then the king made it illegal for Indigenous people, or sorry, that's funny, court made it illegal for lawyers to practice in the Court of Equity. But that didn't work. The courts continued. So then the court just swooped up, passed a law and just swooped up all of these equitable principles to become part of the law. And that's where, you know, procedural fairness and probably the honor of the crown and, you know, injunction remedies and, equitable remedies. That's where all the trust doctrines, that's where all of that became part of the law. And so it could be that we're reaching another brink in the paradigm shift, where if the court can't be seen to be just and apply principles and create remedies which serve the people, then there's going to be other solutions that will grow up, and maybe some of them will get incorporated in the law or maybe not. But people will only use the courts so long as the courts, this is on a voluntary basis, this is the civil courts, where you have a choice to use this dispute resolution mechanism. Criminal court, you're kind of done in, like somebody's using it against you. But people go to civil court for a solution, and if that's not going to be seen as a fair forum, then other things will develop which will take the problem in hand in a different way.
I was in this class of a lot of missing and murdered Indigenous women, and that they haven't received a fair investigation. Can you, as a lawyer, can you give any light on this and how families might go about attaining a recourse?
That's a beautiful question, because it's such a challenging problem. There's so much, I just go back to what George Manuel said when he said that you can't fight things bare bones legal or bare bones political. You've got to do political, legal, the press. You've got to fight on all three fronts. And I think murdered and missing women, we've seen that in spades, where the discretion in the system, and also the racism, which is embedded in that cultural mindset that I talked about earlier, and I only spoke about a small part of it. That is part of the system which we're dealing with when the murdered and missing women are not respected in the same way as if all those women came from wealthy families in Vancouver. We would probably see a very different reaction on the part of the police than what we did see, where they were considered to be street workers or not worthy human beings in the way that it demanded the resources of the force to bring justice to a situation which was just screaming for it. So what do you do when the discretion in the system is not exercised in a way which is just or respectful? And we've seen an amazing solidarity amongst Indigenous leaders and people and organizations and families to bring this to the forefront. And that's part of an artistic swing too. I don't know if you remember The Ecstasy of Rita Joe, that play that played over 40 years. We went to see its 40th anniversary, or maybe it was 50th. And there's not much that's changed, except that now we have, for example, an inquiry, like the Picton case was before the courts, and we've seen inquiries about this, and we've seen public pressure, but the underlying problem that was played out in that play is still at play. So it's really a long story of struggle, and there are legal remedies, like you could perhaps bring an action to compel somebody to do something, like you might be able to mandamus or do a prerogative writ. But the real difficulty with this one is that it's so hard to legally compel the exercise of discretion. Like it's easier to compel when a statute says such and so and so. You can compel somebody to do their job under a statute. But where there's a lot of discretion, it's very hard to actually get a legal dart, that really sticks into the wall in the right place in the right way. So I think it's really what's going on now that we're going to see a remedy, which is the political and the legal, in the form of inquiries and apologies, and all of what's been making headlines is going to make this happen, because the public aren't going to want it. Like people, then you've got the politicians having to answer to their own constituents, and at that point the dynamic changes because it's a political swing.